Okay, so we're going to start that webinar. Hello and welcome everyone to Arbitration Academia's third online webinar in cooperation with Arbitral Women, titled Women of Color in Arbitration, as part of AA's launching series events. Arbitration Academia is the first platform offering online arbitration and ADR services in the Middle East. We provide a variety of arbitration courses delivered by the best practitioners worldwide, targeting law students, lawyers, judges, mediators, arbitrators, everyone in between, and literally all over the world. We also provide legal consultancy and dispute settlement services. For more information on what is Arbitration Academia, what type of services we provide, and where, and also if you're interested in attending our upcoming webinars this May, shortly I will attach our website, www.arbacademia.com, and also our social media pages, Arbitration Academia, in the chat box. In this webinar, we're going to stray away from the rigid and practical topics that we usually offered through our past webinars and lectures. And instead, we're going to make an effort to unwrap a critical and quite persisting topic in our practice, and that is biases against women of color working in arbitration. We're going to shed a light on the facets and nature of both conscious and unconscious bias women of color have to go through. We're also going to assess the effect of such biases on the practical level of our profession. For example, we're going to pose the question, how does biases affect the process of making an arbitral award? We will also dare to dive in deeper through analyzing the efficiency of current anti-biases policies adopted by chambers, law firms, and other stakeholders. We're also going to wrap it up with the big question: what else can we do, and what else should we fix? And the we here extends to the other sex and the other color as well. This webinar will run for 1 hour. In the first 40 to 30 minutes, we're going to have an enriching and hopefully fun discussion with our speakers. And in the last 20 to 10 minutes, we're going to open the floor for our audience to direct any questions or desired commentaries. For now, allow me to introduce our, I would dare say, powerhouse panel. We have with us today Ms. Amal Bouchenacki. Ms. Amal Bouchenacki is a partner at the New York office of Herbert Smith Freehills Law Firm. She's a qualified French and California attorney. She works in international arbitration, advises on complex, multi-tier treaty-based arbitration proceedings, international commercial arbitrations conducted under a variety of major arbitration rules, including exit, UNICITRAL, ICC, ICDR, and much more. Amal is trained in both civil and common law system. She has handled disputes involving an array of complex procedural and substantive issues and industry sectors, including technology, telecommunication, and energy-related disputes, which I had the privilege to work along with her. In addition to appearing before international arbitral tribunals, she litigates international arbitration matters before national courts and manages complex multi-jurisdictions disputes. Amal also has experience in the mediation of international disputes. And finally, Amal works in a lot and many of languages, including English, French, Spanish, Arabic, Italian, and even Mandarin. Welcome, Amal. We are more than happy and more than privileged to host you with us today.
Thank you, Nawal. Very happy to be here, and apologies again that I'm not able to be on camera, but otherwise very present and looking forward to this discussion.
The privilege is all ours, Ms. Amal. Second, we have with us Ms. Sally Al-Sawah. Sally Al-Sawah is a doctor of laws, an experienced international arbitrator, and a leading dispute resolution lawyer. She's Egyptian and French qualified and registered European lawyer with the SRA in England and Wales, acting as arbitrator, counsel, consultant, and legal expert. Ms. Sally is the co-founder and head of arbitration and litigation of Junction in Paris, principal of Al-Sawah Law Firm Cairo. She's also the delegate of the ICC Commission on Arbitration and ADR. Welcome, Dr. Sally. We are more than honored to have you with us today.
Thank you very much. It's a pleasure to be here. Thank you.
The pleasure is ours. Third, we have Ms. Cherine Foty. Ms. Cherine is a senior associate in the International Arbitration Group of Covington and Burling, based in Washington, D.C. She's a dually qualified common and civil law lawyer and spent several years of practicing international arbitration and international law in the Paris office of a major U.S. law firm. Cherine has particular experience in international commercial and investment treaty arbitration, the energy industry, cases involving renewables, environmental claims, and climate change, and much more. Ms. Cherine is a member of the ICC Commission on Arbitration and ADR and the Global Vice President of the Campaign for Greener Arbitrations, where she engages in thought leadership related to sustainability and climate change issues. Cherine holds leadership roles in other organizations advocating for greater diversity, including Arbitral Women, in international arbitration. In 2022, she co-founded the organization Arab Arb, which in one of our upcoming webinars, we will be collaborating with them. So stay tuned. Welcome, Ms. Cherine. We are more than happy to have you with us today.
Thank you so much, Noel. Wonderful to be here.
We also have with us today Amanda Lee. Amanda is an arbitrator and principal of LML Arbitration and a consultant at Cossack & King London. She has been appointed as sole arbitrator on 25 plus occasions and accepts appointments in both domestic and international arbitral proceedings, both ad hoc and institutional. Amanda is a visiting lecturer at the University of Law UK, a member of the Arbitral Women Advisory Council and the NIAC Advisory Board, and also ambassador for real racial equality for arbitration lawyers, amongst plenty many other roles. She's also the founder of one of, or the two of most famous arbitration platforms that we're seeing on social media, and that is Careers in Arbitration and Our Balance. She's also the recipient of the 2022 CPR Award for Outstanding Contribution to Diversity in ADR. Welcome, Amanda. We're more than happy to have you with us. And last but not least, we have Mr. Jean Eken. Mr. Jean is an experienced international arbitrator. He's a triple qualified attorney admitted to practice law in England and Wales, California, and Turkey. Mr. Eken is an assistant professor at Durham Law School. He researches and gives consultancy to law firms, mainly on international commercial arbitration, investment law, contracts, third-party funding, commercial mediation, and other alternative dispute resolution methods. He's an award-winning international legal practitioner, scholar, and arbitration consultant. Welcome, Mr. Eken. We are sure that your contribution will further enrich our discussion today. So,
thank you very much, Nema.
To warm up our session with our audience, we're going to start with posing a question to understand and perhaps define what is racializing of women or women of color in arbitration through sharing personal experiences of our speakers. And so in this regard, I'm going to start today with Ms. Cherine. Ms. Cherine, as a woman of color working in arbitration, has your ethnicity or race impacted upon your career? And I'm wondering specifically here in regard to representation opportunities and retention rates.
Thank you, Noah. Thank you so much for having me here. I'm really, really delighted to share my experience with you all. So I have an interesting profile because I grew up in the United States as a woman of color in a US context. I went to law school here, but straight out of law school, I moved to France. So my experience is a bit nuanced in the sense that my upbringing and my experience in the US throughout law school was in one jurisdiction with one kind of backdrop of, of difficulties and some discrimination as an Arab American woman, and then being taken out of that context and put in a different context. I spent a lot of time in Paris, France, where there equally exists a lot of issues of discrimination against women of color as well. However, as an American in France, I had a sort of privileged status, which was valued, I think, in the arbitration community, being American trained and from an American law school, being a native English speaker. So I did not personally experience in that context as much difficulty or hindrance of opportunities as a result of my status as a woman of color. having come now back to the United States, I'm intensely involved in diversity efforts at my firm and, you know, in the wider arbitration community, because even though I myself may have not experienced it while I was living in Paris and during the fundamental years of my arbitration career, certainly I recognize that it poses an immense issue for women of color who are coming up, you know, as early as high school, undergraduate, and even through law school, even before they get to, you know, their first position as either an associate in a law firm or another legal position. And, you know, for me, what I experienced as a young person in the United States, I feel there is certainly a block, and there are certain opportunities that are not granted to women of color in the same way that they're granted to members of the majority privileged class, that you have to somehow seek to create your own opportunities. And luckily, I think that the legal profession is moving more towards recognition of the fact that diversity is important. Diversity enhances the quality of our legal work. Clients are recognizing this, and a lot of times you see clients now requesting that, you know, pitches that come to them, or the lawyer teams that make up their you know, the teams handling their cases need to be sufficiently diverse, need to have an equal amount of women and men, need to have an equal amount of women of color or men of color. And so this is a fundamental issue that I think the profession has recognized as being useful. However, we're having some, you know, the pipeline of implementation is taking some time. So I'm happy to share some thoughts as to what we can do to speed that up, and I'm sure that my other co-panelists will have much to contribute on these issues. But I hope I've answered your question. Happy to add anything further if it would be helpful.
Absolutely. And thank you, Ms. Cherine, for sharing that. I think it's a wonderful introduction as well, and a great opening for our session today. And perhaps all the women of color who's attending today or will watch the session later on, you know, might relate to the points that you have referred, being as an Arab American yourself, especially, as you said, during the most fundamental phases of your career, and then also your experience in Paris. Moving forward on the first prong of our session, and that is trying to find a definition or grounds for the racialization of women of color in our practice. We'll start with Ms. Sally Al-Sawah now. Ms. Sally, as an arbitrator and prominent practitioner even in our field today, you know, what are some of the current barriers women of color face in their appointment to arbitral tribunals? And do you think, or can you think of strategies to counter such biases?
Well, thank you very much. It's a pleasure to be here. Let me start by two examples. One I was not involved in, and the other one, it's a personal experience. So the first one, in her keynote speech at the ICC 7th conference at the PAL, Yas Bani Fatimi addressed the diversity. This was her keynote speech. And to illustrate by an example, she put on the screen. Oh, sorry, I was on mute. Sorry, was I on mute from the beginning? Well,
just after Yas Bani Fatimi, but then we didn't. Then after that, it was.
Yes, so Yas gave there was a picture to illustrate during her keynote speech. So there was a woman, a lady, on the table with 4 other males. Fairly, she was white, and the others were more like Europeans or Western white also. But the woman was terrified, and there was an old man who was grabbing her hands. And the picture was very, okay, this is the example of diversity. A woman, she was minority, she was white. But also there is this perception that she needs help from the other gender, from more senior men. So this is already gives you the picture of usually how it is perceived, a woman and as an arbitrator. The second, I would qualify, I think, as a young arbitrator. I'm not really young, but I'm not quite senior as well in terms of age. So I was the presiding arbitrator in a Middle Eastern country. And counsel for one of the parties was around into his 60s, and the two other arbitrators, one was a female and another male colleague, and the three of us were definitely younger. So he started by, to escape questions, insinuating in a patronizing manner that we didn't have quite the experience we needed. And then, of course, we did not get intimidated and started to say, of course, thank you very much. We are here to learn from your experience, but if you could please get back and clarify this point in these types of contracts, there is usually this type of clause. So we had personally to prove that we had the necessary experience and knowledge to gain his respect. It is not a given when you are young and a woman, and also from a certain ethnicity, the color. So they never say, well, she's a woman or she's young. But they'll say, well, there isn't stamina, availability, or experience. That would be the thing. Now, of course, things have evolved. Fortunately, in the 90s, there was 1% of females. Since then, things have improved. But yet now, if we get back to appointments, you have appointments by who? Co-arbitrators, institutions, and parties. When, of course, arbitral institutions have done a marvelous job and they're making lots of effort. However, when the arbitration clause says, okay, the center would suggest, but it comes back to the parties or to co-arbitrators, usually male co-arbitrators, usually around the age of 45 to 70, they would never, it's not never, but usually they would not appoint a younger or same age female arbitrator. So this is the first point. Now, if counsel wants, have a more, let's say, more inclusive counsel who wants to suggest something, a female young arbitrator, he has always to justify why he's making this choice and not another choice. So this is also an issue, and therefore how to get back the strategies. I think in Norway they didn't achieve gender equality parity like that. They had to impose a system of quotas, and therefore, at least when you have an appointing that you are suggesting as counsel to your in-house counsel or your client should impose on his counsel at least a 50-50 list where you have female, males, and different regions. Second thing, of course, you can also blank out names and age from the CVs, and you'll see how it can make a huge difference. And last, of course, webinars and other things, because the more you see female arbitrators, the more you get used to it, and the bias eventually will get the way out of it. Thank you. Get out of the picture. Thank you very much. Hope I have answered you. I'm sorry if
you absolutely did. You've absolutely did, and especially when sharing your story about being appointed amongst a tribunal and how you actually had to earn, quote unquote, the respect of not just the clients but your own colleagues, and that's quite astonishing and also unfortunate for us women of color that we have to go through. And as you said, there's many facets and many layers that comes in hand. It's the color and the gender, and this is what we're discussing today, gender and color. But then there's also the ethnicity, which is different. And then there's also where you come from and your spoken language. And on this regard, I would really like to kind of share a question to wrap the first prong of our session, which is, the definition and of what is racialization of women of color in arbitration, and to kind of link your answer with Cherine's answer, you know, I'd like to share a personal story of mine. I think almost 1 year ago, or maybe a little bit less, I was also looking for a position, respectful law firm, arbitration department, a very well-known firm, as a matter of fact, and I applied for their France office, ironically. And, you know, I interviewed first round, second round, they emailed me, you got the offer, associate position. And, you know, hooray, this is wonderful. They've even contacted my references, and they told them that, you know, she made it to this position. Then 1 week later, they made a Zoom call with me, and it was a chit chat, went wonderful. Last 10 minutes, she's now a partner, as a matter of fact, and a woman, right? But a white woman at this firm. She asked me, well, Miss Noel, what is your passport? And I, now everyone would know I have a Palestinian and Jordanian passport. And she's like, oh, I think because we kind of in a rush to hire you, let's change the name and the label from associate to internship. And, that came like a shock to me. I did not know how to handle it. And then when she noticed how I stuttered, she's like, I absolutely understand the way you're feeling. If I was you, I would never go to an internship route by now, considering you're a bard and the number of experience that you have and blah, blah, blah. However, I think the majority of the years that you've accumulated, it was in the Middle East. She said it bluntly, just like that. And so if you come to France, it would be translated in another way. And so that was for me, and of course I never made it to there because it's an internship, but that was an example of both conscious and also unconscious bias on the racialization that we have to go through and how it affects your career path and how it affects your representation opportunities. So thank you, Ms. Sally, again, and thank you, Ms. Cherine, on this regard. Moving forward on the second prong or the second section, let's say, of our webinar today with Ms. Amal, we're going to move a little bit deeper. We're going to assess the effect of racializations of women of color on a more, let's say, practical level in our profession. And so the question is, Ms. Amal, as an arbitrator and also, counsel who worked in countless disputes seated in the Middle East and Africa, do you think the absence of women of color in the arbitral award-making process more specifically influences outcomes in arbitration? In other words, is our field at risk of groupthink, concealing perhaps certain perspectives to dispute settlement, especially in disputes seated in non-white regions?
Yeah, thank you very much. Look, I mean, the reality is, I think maybe a few remarks to preface, what I would say in response to your question. I think, as Sally and Cherine have highlighted, there are many components, right, to the definition itself. There are so many layers in terms of, and depending on where the dispute arises, you can have, for example, in the U.S. context, you could say that there's a wide majority, that the representation of minorities within the U.S. on arbitral tribunal is just appallingly low, irrespective of whether we're talking about men and women. But then in the international arbitration context, if you look at Latin American disputes, then there is a rising bar of Latin American arbitrators that were not present in the past and that now are routinely involved, and an increasing number of women. So I certainly think that it gives hope, I think, to the developments that are going to undoubtedly happen in the Middle East in that regard, both from a men and women's standpoint. Then in terms of, how does diversity affect the decision-making process in a tribunal? I think there are no studies that I'm aware of with regards to that. to really pinpoint the impact on the decision-making process. And I would say maybe extending that reflection to also, who are the lead counsel appearing before the tribunals, right? So until I was looking at this study and I was trying to see if it was updated before this call, and I don't think it has been, but the IDA had just looking, I think at New York State, looking at the proportion of female lead counsel in litigation in New York. And it's still a really strong minority of women who are lead counsel, so first chair in trials in the US. So we're far off both from the point of view of who is presenting the cases to the arbitrators and the composition of arbitral tribunals. And I guess my response has to be empirical because I haven't found a study that actually addresses that. But certainly, and going to Sally's experience, for example, I think there is an element of challenging also the biases that take place in the decision making. So not necessarily gender biases, but say, for example, if you have an entirely, say, gender and cultural homogeneous tribunal, maybe the tribunal members will not spend enough time asking themselves questions that they would otherwise ask themselves because, for example, they would have one of the tribunal members with whom they are less familiar. And that would necessarily, just like in Sally's example, that would necessarily draw them to raise questions that they wouldn't have that wouldn't have arisen in their minds if they had just been amongst their usual sort of club of people, right? So yes, from the sort of the minority member of the tribunal, that means having to, I suppose, proving yourself more because you probably are going to have to answer questions that you wouldn't have to answer if you were part of that club. But at the same time, it does create an amount of diligence, I think, amongst arbitrators that might not have happened otherwise. And that's I think an element of we want arbitral tribunals to pay attention to our cases. We want them to carefully consider our questions, and the more we all come with our biases, right? Both because of how we were educated, where we were educated. So we all come with our biases aside again from gender, just really on how we approach legal issues. But the more diverse a group, the more diverse the biases. And therefore, I think sort of there is, I guess, empirically a diminishment in the amount of automatic kind of position taking on a particular issue if you have a more diverse group. So that's how I would see it.
Thank you, Amal. I think this was elaborative, and also I think of bringing another perspective, I think, on table as well. And just ironically, just a couple of hours ago, I've actually received a phone call from a friend and also a colleague of mine. She works in Riyadh in a U.S. law firm, and she was sharing a piece of a dispute she's working currently on, and she was telling me that we're facing a lot of obstacles with the tribunal itself and also with the opponent parties' counsels. And to be honest, the first questions I posed at her, I asked her, are the parties both Saudi or not? She's like, no, Saudi Arabia a party, and then a French party, and then I'm sorry, Spanish party. And then I asked her what is where are the counsels from? And she's like, well, they're French lawyers. And then I asked her, what about the tribunal? And she said, all males, two from Spain itself, and then the third arbitrator is not even Saudi himself, he's an Arab. However, as we all know, all Middle Eastern countries have civil legal systems, and it's only Saudi Arabia that applies a fully rounded whole system of Sharia law, which means that we're now facing an obstacle, a procedural obstacle, when you're having the opponent counsels not acquainted with the jurisdictions or that they're dealing with, whether as the seats law or as a substantive governing law, because the substantive governing law was, in this case, is also a Saudi law and a tribunal that are also not from there, from the region, the non-white region, you will face some obstacles. And they were actually facing obstacles regarding, what are the limitations and scope of discovery regarding a particular expert opinion. And so the next question was to her, did they appoint a legal expert opinion from Saudi Arabia? And she said no, because they think they're really very well acquainted with the laws there. So yes, again, just to wrap up this question that Ms. Amal has, I think, simply and beautifully laid down to us, there are more procedural issues other than diversity, other than, looking at this perspective from a human rights issue, even perhaps on a practical level in our profession. So with that, I would like, again, to wrap up the second prong of our webinar, which is the effects of biases on the making of arbitral awards process, specifically cases seated in non-white regions. And now we're going to pose the third question, and that is, what are the current anti-biases policies that we have adopted as stakeholders in this profession? And this question goes to Ms. Amanda Lee. Ms. Amanda, what mechanisms have stakeholders in the arbitration regime implemented to counter the exclusion of women of color? And how effective do you think are these measures?
Well, frankly, I wish I could say more than I'm going to say to you now. But stakeholders have sadly been rather lax in implementing specific measures to counter the exclusion, and that's whether express or inadvertent, of women of color in international arbitration. Frankly, we don't even have the data that we need in order to work out the extent of the problem. Institutions don't differentiate their data to the necessary extent to even be able to say, well, hang on, are the mechanisms that have been put into place to ensure that more women in general are being promoted and appointed, are those mechanisms proving to be effective for women of color? We simply don't have the information. We get data about how many women have been appointed, but we don't know where they're from. We don't know their ethnicity. We don't know their race. We don't know their religion. We don't know what their first language is. We need more information. That's got to be the starting point. And there are institutions like the AAA-ICDR that permit parties to, for example, request a further list of potential neutrals if those that are proposed by the institution are not sufficiently diverse. So if you were concerned to see a lack of women of color on the list that had been presented, then as a stakeholder, you could potentially say, well, I'd like a few more suggestions, please. Give me the names of some talented women of color. I know they're out there. We're also seeing the community putting together numerous resources that have been created to try and make it easier to find female arbitration practitioners. We've seen the recent directory of female arbitrators published by Mute Off Thursdays, for example. That includes women of all colors. And there are a number of specific arbitrator directories that focus on people of color from different backgrounds, such as, for example, Americans with an African nexus. We've seen the development of initiatives focusing on women from specific demographics too. We've got Cherine's fabulous Arab initiative, and we've got initiatives such as, for example, Indian women in international arbitration, which focus on particular groups of women of color from different parts of the world. And those initiatives are great. They promote visibility and they contribute to community building and help people to identify mentors and mentees and participate in networking. And all of these things offer a starting point. They all offer a platform to promote women of color, but frankly, there's a lot more to be done. And as stakeholders, we all have a role to play and must be mindful of things like bias, both conscious and unconscious, when we are shortlisting, when we're recommending people, when we're allocating work within our teams and so on. I really wish I had more to say, frankly, but we are where we are.
Yeah, That's all that we have to reflect on, I think. And regarding the platforms that are just starting to provide data regarding the diversity of arbitrators sitting on international disputes, specifically in cross-border disputes, we had Arbitrator Intelligence, Catherine Rogers, working on that regard, and I think that was also a great initiative. But I think you're right. There's much more to do, and I would like to pose a follow-up question on this regard. And this is something that it's valid. We have witnessed ourselves as practitioners in the field, and if you read about this and you go to the literature, they usually ask these questions and leave it open because they assume this is something, and perhaps they're right, we can't really control as lawyers or arbitrators or law firms or chambers. And that is the role of the client, right? So again, I went online and I've been reading, what chambers, including the ICC or law firms, have been doing to, advertise for diversity when it comes to race and also gender. And they always, wrap this article or this blog with, but there's the client factor that we're unable to control. There's a client who walks in the door and they specifically ask and request for, a certain arbitrator. And we all know in arbitration, parties have complete will and authority to appoint their own arbitrators. What can we do on that regard, right? Is there something, Amanda, that you think we as law firms, again, as lawyers, as arbitrators, as chambers, as institutions like Arbitral Women can do, I don't know, to further enhance the client's factor in this question?
I mean, it's a difficult question. It's a difficult challenge. As advisors to our clients, we are in an excellent position to influence their judgment when it comes to appointing arbitrators who are women of color. But in order to do that, we need to have sufficient information about arbitrators who are women of color, or potential co-counsel who are women of color, or experts who are women of color, in order to be able to explain to our clients why these are candidates who should be selected instead of the grand old men of arbitration, or the usual suspects, or the female pale stale arbitrators who are potentially rising up to become part of the status quo. And that means that we need to understand what it is our clients are really looking for when it comes to arbitrators. And predictability, of course, is a big component of that. And that's one of the reasons why Arbitrator Intelligence was collecting data. They were trying to analyze what it was that made certain arbitrators a credit to the market. Who were the arbitrators who were doing a really good job, perhaps in their domestic markets, but they hadn't broken onto the international stage yet. People simply were not hearing about them. And so we continue to have this unfortunate sort of chicken and egg information problem. Clients can only be persuaded to do things on the basis of sound advice. After all, clients are spending a lot of money and a lot of time pursuing disputes. And we need information about talented women of color in the field. And as stakeholders, as practitioners, as counsel, we need to be supporting each other and recommending each other and sharing information about each other and getting the message out. And I appreciate that in some jurisdictions, including many jurisdictions where women of color are practicing, it's just not normal to be ringing your own bell all the time. Self-promotion is seen as culturally insensitive in some jurisdictions. And that may mean that practitioners are reluctant to share information that shows how talented they are, how they would be ideally equipped to sit in this particular arbitration, or they have knowledge of the law of this particular seat, and so on and so forth. We've got to get better at identifying ways in which we can champion talented women of color. And I say we, as a member of the arbitration community. Obviously, I'm not a woman of color unless you count sort of off blue as a color. So, you know, but I still see myself as being an ally and as someone who can play a part in championing talent. But we need information, frankly.
Absolutely. And, you know, I couldn't agree more. And I think more on this issue of policies, and now from a different perspective, you know, we're going to now go ahead with Mr. Jean Eken. Mr. Jean, you know, as a male arbitrator, right, and a very prominent one, as a matter of fact, during your position as a partner, meaning a decision maker in Eken and Partners law firm, what policies did your firm implement to increase the representations of women of color, and, you know, which have proved effective? And are there others that you would consider now, after, you know, a trial, to adopt?
Naval, first of all, thank you very much for this kind invitation, and I'm very happy to speak in this panel as the only male arbitrator, practitioner, and academic, and to express my opinions. And definitely, I must say that in my firm, I was the solo practitioner, but in arbitration cases, I acted or I advised. I always worked with different law firms from Turkey, India, China, so in different regions. And I worked with some law firms which was male dominated and which was female dominated. So in that regard, I would say that sometimes there are not much choice on my occasion, because I just involve the team. Either I lead the team or I participated the team. But I can suggest some general advice for many law firms, actually, that can be applied. And I apply this in both academia and practice as well. First of all, I think the recruitment panels must be definitely a gender diverse recruitment panel. I don't mean here placing only a woman in the panel. If it is a 6 people recruitment panel and there's only 1 woman, this is not a gender diverse recruitment panel. And I must also add here, there must be also the gender diverse, but also ethnically diverse panels. Because in your case, I think what you shared, Naval, is outrageous, actually. Even a woman, but a white woman, basically offered you a lower position just because of your, after learning your passport. I think this is outrageous, and we should all acknowledge that, and we should really point such practitioners, because this is an international arbitration practice, and we should always stick to the best practice, and this is not definitely a best practice. So I think recruitment panels should be in this ethnically and gender diverse panels. And then another idea, definitely some companies set up equality officer position, which is also useful. There should always be a consideration for the gender and race. And I think one important aspect also that non-US and non-developed country experience should be counted. If we only count the experience in arbitration in Paris or London or New York, and then all the other experiences in India, in Pakistan, or in other countries around the world, non-developed country experience, we don't count it. This is definitely not equally represented arbitration practice experience or arbitration practitioners. And there will be always a huge gap between the practitioners from the developed countries and non-developed countries. So if we are truly practicing international arbitration, I think all the experiences should be counted equally. Otherwise, there will be major effect a dominantly represented US legal system or Paris or London legal system, but not a truly international one. So there should be some deliberate choices, and we should be very careful about this and always include very diverse decisions in our judgments.
Thank you, Mr. Jean, and I couldn't agree more. And specifically when we're, addressing a dispute and cases that are, either seated or subject to the substantive governing law of a non-white country or a non-white region, it makes absolutely sense to instead of hiring, a white counsel and plus a legal expert opinion, just simply and to appoint a legal counsel from the region who would just cut you cost and time and I think procedural obstacles as well. So thank you, Mr. Jean. I think now would like to go back to Ms. Cherine, and I'm going to pose the questions here on hopefully a more practical one, sharing a little bit of tips, a little bit of advice, again, with our audience, everyone who's listening, everyone who will be broadcasting later on. Mr. Cherine, do you have any tips for women of color in advancing their career in international law firms specifically? And in what ways is your platform ArabArb working towards promoting Arab women, again, more specifically in arbitration?
Thank you so much for the question, Nawal. Sorry. We have, maybe I'll explain a bit about ArabArb first to the group so you can know what it is. So ArabArb was founded by myself and 4 other women, and we're very happy to have Amal Bouchenacki on our advisory board. So I'm delighted that she has agreed to support us in an advisory capacity. We founded the organization last year, and ArabArb is an independent association which aims to unite, promote, and serve initially the US based arbitration community, which has roots and affinity in the Arab world. However, when we launched the organization, we got an enormous amount of feedback and interest from our fellow Arab arbitration practitioners all around the world, whether that be in Europe, in the Arab world itself, in various arbitration hubs. So what we decided was to expand our reach, not to be only US focused, although that's where the idea kind of grew out of, being part of the Arab diaspora located in the United States. We decided to have more of a global reach, and will now be establishing hubs in different arbitration centers around the globe. And what does ArabArb attempt to do? Well, we seek to provide a platform for arbitration practitioners to network and collaborate with each other, to contribute to the common goal of advancing knowledge and understanding of arbitration as it relates to the Arab world. And that's done in a number of respects, based on the substantive content of the law on arbitration that comes out of the Arab world, but also in relation to procedural and the makeup of the arbitration community as it affects arbitration. So in particular, we aim to create and increase the visibility of Arab arbitration practitioners and arbitrators, as well as experts and other members of institutions and other stakeholders in the arbitration community, who are particularly, to follow up on some of the points mentioned earlier, particularly well suited to handle these types of disputes. When someone has training, grew up as a lawyer in an Arab world jurisdiction, then they are able to uniquely handle disputes that come out of that region. And all too often, we have seen, panels which are entirely European or entirely, North American, where representation from the region is not adequately seen. And that's something that as I believe Amal mentioned, in Latin America, we're seeing increasing numbers of locally based arbitrators who have that substantive and procedural knowledge from the jurisdictions, being able to really adequately decide these disputes in a nuanced and fully informed manner. And now we need that in the Arab world, and we're starting to see it a little bit, but we have an enormous amount of progress to make. So our organization seeks to not only provide that community and promotion of substantive knowledge, but really to say, there are highly qualified individuals capable of handling these disputes as counsel, as arbitrators, and otherwise. And we also invite students into the fold by providing mentorship opportunities and seeking to provide tools and skill sets that can be useful for the practice of international arbitration. we happen to be an all-female board and an all-female advisory board. So that just goes to show you that there are a number of, Arab women who are, suited to handle these disputes and to, create this community. And we've gotten an enormous amounts of responses. So to come now to your question, and sorry, so we invite everyone to, to join if you're interested in the organizations, open not only to women, men and women, and you don't necessarily need to be, of Arab ethnicity in order to join. If you have an affinity for the region, if you practice frequently in the region, we more than welcome you to be involved, and we would be happy to have you. So to come back to your initial question, what are some skills, and what tips do I have for women of color who are seeking to advance their career in international law firms? I would say there are a few things you can do. Number one, your diversity is an asset to your law firm. Your diversity is something which is coveted and which is sought out, and it's a tool to be used in your promotion and evolution at the firm. So it's something to be celebrated and represented, and not something which you should feel as a hindrance or an obstacle in your career progression. So from a self-viewing standpoint, I think it's important to recognize that initially, because it will kind of color the way in which you conduct yourself in that environment. Secondly, I would say don't be shy to seek out opportunities and request chances to learn and evolve. It is really important to get the opportunities that you need in order to progress within your career. And if you are not provided with those opportunities, you should demand them. You should seek them out. You should go directly to the partners you're working with and ask for those specific opportunities. And yes, it will mean some additional work. Yes, it's going to be a little bit tiring to try to manage everything, but as we know, as people of color, our excellence needs to be top-notch in order to be successful in this career. So seek those opportunities, prove yourself effective at the way in which you handle those opportunities, and hopefully that, at least in my experience, has opened the door to other opportunities which come after that. Number three, I would say, relationships are everything. Relationships are extremely important. So it's important to find someone who is going to champion you, who is going to promote you and chaperone you. As was mentioned earlier, especially in the Arab community, we are reluctant to engage in self-promotion. It's something which is not necessarily, humility is an essential part of our culture. So if you do not feel comfortable doing it yourself, which I think many of us do not, you can establish a relationship that allows for you to be celebrated in a way that doesn't necessitate, you to be engaging in that. And that's what I found to be most effective, at least in my personal experience. And relationships can mean many things. Relationships can be, having a mentor within your firm, someone who can kind of give you the ins and outs and inform you as to how things work and what are the best ways to approach different things. You should also have, multiple relationships are important. So also just knowing a wide array of people within your firm is important. Establishing those connections early on across the board, even if that means like in different practices, so that you feel comfortable with just being knowledgeable about what's going on at the firm and hearing about potential opportunities which may arise. And then third, I would say relationships need to be quality relationships. So I think especially in the US, people place a lot of focus on, networking is so important, networking just for the sake of collecting a business card won't get you very far. But networking where you establish a personal and meaningful relationship with someone will certainly get you farther. If you're able to relate to someone on a personal level and learn from them and kind of replicate the advice that they provide to you, the relationship will be much more meaningful and will also be much more beneficial in the long term. So I would absolutely suggest establishing that. And then very last point, and I won't go on much longer, I would say, you know, excellence is essential to our progression, but sometimes you make mistakes and sometimes you have, you know, you don't get that important opportunity or you don't have that exposure that you want to the specific case you want to work on. Don't let that be a hindrance to your progression. So seek out, you know, a follow-up opportunity, or if you're not able to get one thing, you know, create your own opportunity in a different context, whether it's a pro bono context, whether it's in a non-billable capacity outside of, you know, your client work, and, you know, build up your experience and knowledge in that manner. So don't let those obstacles prevent you from learning and evolving. So I'll stop there. Those are just some tips, but I'm sure there are many more.
Thank you, Cherine. I think those are very practical, and this is exactly what the question kind of was trying to hone from the answer. So again, thank you for that. You know, I think I would like just to add a comment regarding the excellency. You know, my personal opinion, I'm not sure if you know, being overqualified and trying to prove yourself all the time is the key. As a matter of fact, I think it is part of the dilemma, part of the issue that we're facing, part of being racialized. And but you know, I think it was very important to hear that from your own perspective, because it was obviously kind of the main gate of getting a very successful, very intellect, very you know, established woman like yourself to where you are now. And that's just a model, and that's exactly what we're trying to highlight and stress in our webinar. So thank you, Cherine, for sharing those tips and also for introducing Arab art to our audience. I think there's Ms. Bouchenacki. She's Tunisian, based in Paris, who would love to join you, and hopefully also our other audience. So thank you for that. Moving forward, or kind of coming back full circle now with Ms. Sally on the questions of what can we do as institutions, but for this time we want to take a spotlight and focus on Arbitral Women, specifically since they are our partner in this webinar, and also since Ms. Sally herself is a board member at Arbitral Women. So Ms. Sally, is Arbitral Women currently involved in the development of programs or policies to empower women of color, more specifically in arbitration? And if there are, what are those programs or policies that are taking place? And how has the work of Arbitral Women developed over the years in this regard?
Well, thank you very much for this question, and I'm very glad to be and actually honored really to be a board member of Arbitral Women, and we have with us also Cherine and Amanda, who have been in the institution for much longer time than me. But before talking about it as about Arbitral Women as a board member, I would like to share my own experience as a member of Arbitral Women. When I went to London, it's amazing because I discovered Arbitral Women when I was in London. I was coming from Paris with my package of experience, with my self-esteem, with my PhD, you know, and I come to London. It's a completely different culture. It's a different mindset. Self-promotion is key. How to promote yourself in a completely different set, where usually it's Oxbridge who are in the limelight, and you know, you're coming from Paris with some ideas, and then you discover it's completely different. And Arbitral Women, actually, I've become a member. At the time, it was the pledge, actually, the ERA pledge, and I signed it and signed up for it. I remember very well, and I became a member at that time. And it was thanks to Arbitral Women members in the UK who encouraged me, who literally helped me with their time, and that I got my self-confidence respect to my experience and all this. This is part of the role of Arbitral Women, how they promote women in general. Now, coming back for the programs right now, I'm a member of the educational program committee, and this year actually we have sponsored the Wismut in Vienna and the Wismut. We have sponsored 29 teams. Most of them are not from European countries, and those who come from European countries are not the wealthy countries we are used to. We have also fully sponsored 4 teams: Nepal, Lesotho, Tanzania, and Iran. At least 50-50 member females. So, you know, these are not people from, this is really promotion of non-white females. We have also 2 awarded in 2021, 22, 50,000 euros for 2 organizations dedicated to the legal education of young women who cannot access actually education. We have the CLUE program, which is a Cambodian, and also the CBP, the capacity building project. We have also all the time publications on our LinkedIn page and our social media, news alerts and newsletters about, and we are also media partners of many webinars and events where there are female arbitrators as speakers or as organizers in general, and especially when they come from regions other than Europe and the US. It's more, I mean, we're more keen to become media partner with them. We have, of course, and I will not be very long because we have with us Amanda Lee, the diversity toolkit, Arbitral Women diversity toolkit, and it's all how to fight unconscious bias, how to be aware of our own biases, how to respond to bias and progress toward diversity and inclusiveness. So this is part. I cannot talk. I can spend the whole day about talking about what they do for promotion of women, but I'll stop there. Thank you very much.
Thank you, Sally, for highlighting and stressing both your opinion as an Arbitral Women member, but also as a board member, and also for laying down for us really the programs and policies that are heading there. It's definitely a good starter. It's definitely efficient. It also definitely on ground, meaning it's not just ink on the paper, as they say, and we're all here for it. Ms. Cherine, I think she would like to add something.
Yeah,
Please
I would.
ahead.
Excuse me, sorry to jump in, but I did want
absolutely.
one important point. So Amanda talked a great deal about information and data gathering in relation to diversity. And I just wanted to highlight one activity of Arbitral Women, which was in fact started by Amanda, which was to promote the news of its membership, so of female arbitration practitioners or arbitrators, to give visibility to their accomplishments in a way that kind of strays from the self-promotion aspect. So, you know, when someone gets promoted, when they get a new position in their firm, when they move firms, when they start their own arbitrator practice, or when they receive an award, Arbitral Women actually highlights that and promotes that both on social media and on its website. And that kind of visibility element is so important to, you know, recognition of information and just knowing who is out there and what their capacities are. So I just wanted to quickly note that. Thank you.
Thank you. And, you know, I think this is one of my personal favorite activities. And actually yesterday, Arbitral Women uploaded the most recent promotions, tracking women in general, and obviously also women of color as well in arbitration. And again, this is something that we need both for data collecting purposes and knowing how to tailor our upcoming policies and steps, whether at a law firm, at a chamber, or whatever you are, and also for promotion. As you said, there are certain jurisdictions, there are certain people that are timid, let's say, to self-promote, and this was a really efficient tool. So thank you, Cherine, for jumping in. Now I think I would like to proceed on this regard, and with Ms. Amal Bouchenacki, we're going to ask her a question on how, let's say, not the hiring of women of color process in big law firms specifically, but how after the appointment of women of color in arbitration, what are the distribution ratio of cases and works and tasks given to such women, given to such category? So the question, Amal, is how do law firms, and again, we would love to hear your own experience as a partner at HSF, achieve greater equity in the distribution of cases or tasks in general to better represent women of color? And have you noticed any differences in the dispute resolution process when led by women of color?
Yeah, thanks, Noelle. I'll try to be short. I know we're coming to the end of the hour, but things have changed so much in large law firms in this regard. I mean, so we started out with a system when I first started, and I was a trainee a long time ago. The only way where the cases were distributed on the basis of what certainly the partners considered as a solely merit-based distribution, right? If someone, you were very good, so you would be assigned more and more work. And I have to say, just like Cherine, I have not suffered from any bias in that regard. I was always a very busy, I was given a lot of opportunities to advocate early on in my career, to just take on a lot of responsibilities on my cases. But what this diversity discussion has brought to law firms is recognizing that when you think you're only basing your assignment of cases on the basis of merit, you're actually also, there is an element of unconscious bias that you have not factored in unless you have intentionally decided that you were going to take it into account in how cases are assigned and opportunities are given. So I think this has changed in large law firms, certainly in ours, tremendously. There is an element of really seeking to empower. So it's a two-way thing, right? The firm has to empower its minority members, because firms really want to promote now, as Cherine was saying, really want to promote their cohort of minority members. And then it's also a matter of very proactively for members of minorities to make sure that they're not overlooked, to feel an entitlement to be given the best quality work that they can have. And then it's the job of the partnership and the senior lawyers to continuously convey that they want people to do that they want people to be proactive about their careers. So there are a number of initiatives within law firms. All law firms are doing that. I think a number of law firms are doing that very effectively. Certainly for us, I think we're really seeing a change in that regard, and I don't think that there is a level of inequity now in terms of the quality of work. I think it's the difficulty is in these firms is getting your foot in the door. I think that once you get your foot in the door, it is actually I find fairly equitable now, the way things are distributed, the way clients want to see our teams being more diverse. And so tribunals, in fact, for example, for us, we always give as much early advocacy opportunities as possible to our more junior team members. And what we've noticed is actually tribunals really like that. They really like having the more junior team members have advocacy opportunities. And I think it's essential for international arbitration practices. I think one of your, going to your earlier question, does it change? One of the earlier question was, how does that change the quality of the work? It does. It does. When you have a cross-examination that's conducted by a more junior member of your team who has been living with every document of the case, it is very effective if you're giving the right training. And so that's what we do, ongoing training, ongoing support for professional development, so that we give the tools for our junior members and less junior members to really be empowered.
This obviously makes us all optimistic, and especially again coming from Amal, which is again, she's a partner at HSF, and to hear that law firms are actually on real ground and away from the literature and the advertising that we're seeing, that they are implementing and actually desiring more diversity, whether in appointment in tribunals or as she herself stated, this distribution of work and cases in a firm, and I think, fairly so, during my experience at HSF in New York, that was the case. I think, there was only 2 to 3 men in the arbitration department. We were mostly women, and we were, right?
I think, yes, HSF in New York is a fairly, yes, we're very, we have a large majority of women, in fact, in the team. Yes.
We were almost all women, and we had Christina from Singapore, we had another associate from Jordan, and there was a fair, and then we also had quite a big team from Latin America as well. So again, we're quite glad to hear that firms are heading there, and they're taking this more seriously into consideration. Moving forward now with Miss Amanda, and now we're kind of diving into the rabbit hole of getting ourselves in the mud of more philosophic, more psychological aspect and perspective of this question or this issue. Miss Amanda, is there a role for white women to play in countering the exclusion of women of color in arbitration, and how might they offer support without falling into the white savior trap or archetype?
Short answer, absolutely. There's definitely a role for white women and white men to play in supporting, promoting, and championing women of color in arbitration, just as there's a role for men to play in promoting women in general, and for heterosexual people to play in supporting LGBTQ+ colleagues, and so on. What I've been told time and time again is that those who are seen to be advocating for themselves face criticism. And so the voices of allies are therefore of value. What do I mean? Well, when we speak to advance our own causes, we stand to benefit from such advocacy. So when I promote gender diversity, I'm perceived as doing so from a position of self-interest in a way that a man would not be. For example, I say, yay, more women in arbitration. They go, hang on a minute, you're a woman in arbitration. I can see what you're doing here. However, I'm not a woman of color. So if I talk about women of color in arbitration, it's a slightly different lens through which to look at the philosophical underpinnings, shall we say. So how can white people support our colleagues of color? Well, Robert Livingston, a well-known Harvard social psychologist, and this is the philosophy coming in here, talks about there being 3 different metaphorical types of people in the fight for social justice. And he calls them dolphins, ostriches, and sharks. And I want everybody listening to think about which of these 3 types of people you are, okay? So be thinking about this, because I'm going to describe them. Now, sharks are people who like the status quo, and they like inequality because it benefits them. And the only way they will act to promote positive change is if they're pushed into it. If there's a PR problem or something, and it suddenly becomes really important that they promote diversity. If we talk about incentives to make people act in terms of carrots and sticks, sharks are not going to do anything unless you hit them with a great big stick. And we all know a few sharks in this field. And we then have ostriches. Ostriches either don't care or they don't really know enough about what's going on to make a difference. They're not going to do the right thing just because it's the right thing. You might need sticks, you might need carrots, but you're going to need something to get the ostrich to actually act and do the right thing. And then last but most importantly, we have dolphins. And the dolphins tend to be fundamentally decent folks who care about good things like diversity. And if you appeal to their better nature, they'll probably get on board. And lots of us would put ourselves in the dolphin category. Lots of people, if you ask them, would say, we agree, we need more women of color in arbitration. And they'd mean it. They'd mean it sincerely. But unfortunately, we actually need a little bit more than that. Because Robert Livingston reminds us that there's two different types of dolphin. There's the swimmers who are on board with the idea of good things like diversity and supporting women of color, but they're kind of swimming below the surface of the waves. So they're quietly liking that post on social media about the launch of Arab Arb, or they're saying, yes, this person is really good, and we should quietly talk about that, but they're not actually getting out of their comfort zone. And then we have the leapers, and the leapers are the people who go the extra mile. It's difficult to leap. You have to leave your comfort zone and act, and you have to stand up for what's right, and you have to stand up for what you believe. You're literally leaping out of the water. And if we want to move towards racial and gender equality in arbitration, then we need more dolphins who leap. And what I think I can say, and you can tell me if I'm wrong, is women of color are having to leap all of the time in arbitration. It's exhausting. You're constantly having to throw yourself over the precipice and go, hey, hang on a minute. And so white women in arbitration and white men in arbitration, white people in arbitration, we need to join our colleagues of color who are having to leap all the time. So what can we do? We can share news about talented women of color in arbitration, particularly those coming from jurisdictions where it's culturally inappropriate to ring your own bell. We can recommend them to our clients. We can put them on shortlists for arbitral appointments. If you are sitting as a party appointed arbitrator and you have to pick a presiding arbitrator, we can make sure that we are including talented women of color in those lists. We can invite them to speak on panels. We can ask institutions to give us lists that include not just women, but women of color. We can do things that mean we are pushing against the status quo if we see that women of color are not being given opportunities. So what can we do? We can demand change. Basically, we need to stand up to the sharks, energize the ostriches, and nudge those little swimming dolphins out of their comfortable watery quarters. So instead of just liking posts and going, oh yes, it was a very good event on diversity, very good, we're actually acting, we're actually doing positive things, because none of us are getting any younger and we need to change. So that's what white people can do to help. You can leap.
Thank you, Amanda, for, me and Amanda were just discussing this question before we went live, and like, oh, what can we say? Because, this needs a lecture by itself, and this is very layered, and how can we really connect it to the practical aspect of our profession and this webinar and the platform that we're currently speaking on? And I think you beautifully had put it in a very simple way, and in a way that I think makes each and every one of us, both the speakers and also the audience, reflect who are we and what can we do. And so again, thank you, Amanda, for this answer. Moving forward with Mr. Jean, and with this question, we're going to wrap today's discussion, and we're going to proceed on tiptoeing on those, not very rigid illegal frameworks when it comes to representations issues in arbitration. And the question is, what about patriarchy? What role does it play in women of color's exclusion in arbitration? So Mr. Eken, the question is, does patriarchy play a part, perhaps maybe enhance the struggle of women of color in arbitration, specifically from a perspective of a male arbitrator? And have you observed any differences both regionally and temporarily regarding the treatment of women in general and also women of color in arbitration?
Thank you very much, Neval. It is an easy and a difficult question at the same time, but I will just share my own experience. I studied and worked in many different jurisdictions, including California, London, UK in general, actually, and then Luxembourg, Turkey, and Hong Kong. So I have spent many times in different parts of the world, and I'm happy to say, actually, wherever I go, I have more women friends, colleagues in my classes, in my offices generally, than male colleagues. So this is a good thing. Even now I'm teaching at Durham University, and I'm happy to say that more than half of my class are women, female students, so which is a great thing. But I believe in general, definitely patriarchy plays a different, an important role when it comes to the higher female arbitration practitioners or choose an arbitrator. So in that sense, I will just share again my own personal experiences, because I don't want to say something theoretical and not reflected in the practice. But my own experience, I actually interviewed funders during my PhD thesis, and I talked to nearly 30 different funders around the world. And I can say that unfortunately this inequality is represented in the funders as well in the legal practice. In maybe academia, we are promoting diversity more than maybe the industry itself. That's why wherever I go, I'm mostly in academia, and all my legal practices attached to academia can be maybe more diverse than the real industry, which has no connection to academia. So in that sense, I promote actually academia and academic connections, because all the universities I spend time with, they promote equality, diversity, and inclusion, which are equally important. But when I interviewed funders, I can see that most of the interviewees I spoke to were male funders. So it is very clear, actually, I can see that many more practitioners, funders, are there, prominent ones are males. So there are definitely different reasons, but patriarchy is one of the important reasons, I guess. Maybe unconscious bias in the people's heads because of culture or because of different reasons. It reflects itself. And how can we resolve this issue? I think we should focus on this, but that is the difficult part. That is the difficult part, how to resolve this issue. And I know that we are over the time already, so I don't want to talk more because we can extend the answer. But the main solution, that one simple step I can suggest, is that I think all of us should always stick into the diversity and promoting the diversity. Whenever we have a difficult decision, as Amanda said, we don't have to belong to that particular group to promote such diversity. So that's why I don't have to be a woman to promote women diversity. Again, in the same way, in terms of ethnic diversity as well. So I think we should do this. And with this kind of webinars, thank you for organizing again, and I'm happy to participate for this reason. I think we should talk about this, be vocal about this, and then in our decisions, we should reflect this, and hopefully we can change the direction of the practice in terms of the diversity in our practices, more towards more diverse, more really international practices, and we can see this in every panel that we are practicing.
Thank you, Ms. John, and for the way you wrapped it as well with your final two statements. Let's hope for a real international arbitration practice, and not international limited to the US or the UK or, you know, Singapore, even now on board, right? Let's hope for also a real diverse ethnical and racial practitioners in the field, and real meaning not only white. So thank you, Mr. Jean, thank you, Amanda, Ms. Amal, and Sally, for this very layered discussion and heavy discussion as well. Now we're going to have only 2 to 3 minutes, just because we're already late on time, for questions and commentaries. And I see here in the chat box that we have a question from Ms. Rima Bogisha, and her question is, how far can we actually promote representation when the client plays a major part in choosing the law firm and the arbitrators? So this is kind of, you know, this is kind of a question that I've also imposed, but if any of the speakers wish to participate and answer the questions, please go ahead.
I can jump in. Oh, sorry, Cherine, do you want to go?
No, go ahead, please, Amal.
No, I just, the only thing I would say is, as Amanda said, we do have an element of influence on our clients, and, you know, clients want to do the right thing. So you have two categories of clients, I would say, to simplify. Those who really don't care about doing the right thing, who don't think that it is their job to do that, because they consider that what they need to do is go and, you know, run their business as well as possible, and that does not include equity. The other category, which is a growing category, are people who recognize that actually it could be good for their business to do the right thing. And so they are open to our recommendations, and they are open to us being participants in all these platforms, precisely to develop our personal knowledge of the participants in this community, of a greater diversity of participants in this community. And that's why I really commend you, commend Cherine, commend everyone who is creating these platforms, because what clients ask of us is, so do you know this person? Have you met this person? And, you know, even if that person hasn't, you know, particularly in the investor state context, I guess, you know, you look at, for example, number of appointments. If you're selecting your list of arbitrators for your clients on the basis of the number of appointments in exit arbitration, you're going to get, you know, you have to go down to, we did the exercise not so long ago. It was disheartening. You have to go down to, I think, 3 or 4 cases if you want to open up to a list, a broader list of potential arbitrators. So you need to have your clients convinced that it is worthwhile going with someone who you know personally is a very good lawyer, who has all the skills to sit as an arbitrator, but has not necessarily sat as many times as the usual suspect. So there's an effort for us to participate in these platforms. And I think for also younger lawyers, which I'm no longer part of that community, unfortunately, but very happy to support, to really develop these connections, because that's what makes us be able to recommend people to clients, that we can say, yes, we've met this person. Yes, I heard her speak. Yes, she is very articulate. She has that kind of personality. This is how she would fit, so that we are not coming back on the same usual suspect.
Thank you, Amal. I think this is, you know, both theoretical but also practical, and this is something we need to take into consideration. A client, when they want to appoint an arbitrator, they would always ask not just about their profile, but how they actually work in real life. I mean, we all have glamorous resumes on paper, but how do you actually work, and who knows who, which is what Cherine also stipulated in her first answer. Networking is something very vital and important, not just to heal the issue of, you know, racial inequality or gender inequality, but also because it is integral to what we do as lawyers and arbitrators. It is our character, and our practice is at the center at the end of the day of what we do. So thank you, Amal. Due to the very tight time that we are already on, we're going to share only one final question from our audience. And this question is from Professor Mohsen Al-Attar. His question is, well, thanks for a stimulating discussion. I noticed a tendency to individualize the problem, placing emphasis on the behavior of individuals, both positive and negative. So is there not a systematic dynamic to inequality and the discrimination that flows from it? Should we reflect on these elements as well? I think it's a very brilliant question, to be honest. So let me know if any of our, you know, honored speakers would like to answer this question.
I can just very briefly mention one thing. So I entirely agree that, you know, there are 2 elements to every issue of discrimination. One is, how do we address the systemic nature of the inequality on a broader societal level? How do we take action to, you know, negate it and move past it? But secondly, you know, what can we do ourselves to further ourselves as a community in the meantime until the societal inequality has been remedied? And so I think that's been, as you've mentioned, a large part of our focus here, because we still are in a system of societal inequality. But there have been I think there's been a targeting of broad initiatives as well that we haven't necessarily addressed in that much detail today, which have sought to, you know, move past the societal inequality, or at least start to address it. And that's been, you know, institutional moves towards the collection of data, institutional moves towards full gender parity. So for instance, the ICC was seeking to promote more and more women, and made an executive decision one year to just say, you know, half of our court members need to be women. We want full gender parity, half and half. And with a single decision, we're able to move from incremental, you know, steps up to gender equality to, you know, full parity in a single, you know, in a single decision. So those types of broad, wide impact initiatives are going to be essential, and I believe, you know, deserve our attention and concentration. And I just wanted to add one final very quick point, given the time. You know, oftentimes we have this ping pong between, you know, clients aren't really sensitive to issues of diversity. Oh no, it's counsel that are not so sensitive to issues of diversity, and it just goes back and forth. You know, we don't want to push the clients farther than what they're comfortable doing, and then vice versa towards counsel. All I can say is I think initiative from one or the other is necessary, and even where your client is not reactive or sensitive to those types of issues, take the lead as counsel, propose these individuals, be very outspoken in, you know, trying to promote, like your first list of potential arbitrators, make them equally diverse, make them, you know, half women at least, if not, you know, a full list of majority women, if that's something that, you know, you have qualified candidates for, and be the proactive, you know, individual in that relationship to bring that forward. If you're on the client side, do that yourself and push your outside counsel to make those moves. So don't let the excuses kind of get in the way of making this progress.
Thank you, Cherine, you know, for sharing this proposals, or let's say points or ways or methods where jointly they might actually create a whole system in, again, resolving and healing the, I think, the diversity issue that we still have until this very day, whether in law firms or chambers or even ad hoc tribunals and much more. For now, I would like to wrap our session for today. Thank you, Ms. Amal Bouchenacki, for attending with us, Ms. Salil Sawah, Cherine Foty, Amanda
Thank you very
Lee,
much.
Mr. Jen Eken, for your participation. On behalf of Arbitration Academia, we also thank our audiences, everyone who attended, who asked questions, who commented, and who will also be attending our upcoming webinars. Apparently, we've seen a lot of engagement with our audience, inquiring and asking us about Arab ARB. So stay tuned. We actually, in a week, we have another webinar in joint with Arab ARB. Thank you, everyone. Have a good night or have a good morning wherever you are.
Thank you.
Thank
Thank
you.
you very much to our fabulous moderator and audience.
Yes, absolutely. Thank you so much for having us, Noel.
The pleasure is all mine.